Yeah, to unpack the implications of this, I'm joined now by legal expert Tyrone Maseko and political analyst Professor Sipho Seepe. Good evening, gentlemen, and thank you very much for your time. Tyrone, is it common knowledge now that, or common cause, as it were, that this information was leaked and Section 46 was breached, or is this something that would still need to be decided by the courts?
Good evening, Tabo. I don't think it's common cause, Tabo. We got to be careful. So you have to think back at the arguments that were made in this regard the last time that the parties appeared. And from memory, and this is actually quite interesting, is that the argument that was made is that, well, certainly the defense is that Advocate Billy Downer did not himself leak the documents. So to start with, as I recall, it was, and I stand corrected on this, but it would have been his junior or at least his colleague, Rothenbach, who actually was a participant, who actually disclosed. So the interaction between him and Karen Mona was really between the two of them. So the link with Advocate Downer is really an assumption and an inference that it would have been part of it. So that is to answer the direct question of Billy Downer's actual participation. There's actually no proof of his actual participation in the disclosure. Then we can move into the question of, well, what is the status of this disclosure? And from memory again, the status of this disclosure was that, yes, there's a concession that the information was provided to the journalist prior to it being filed in court. And there was, and on the proviso that they would not publish it until it was actually submitted in court. And that was to then deal with this rule, this court rule, which basically states that, in essence, documents become public knowledge once they are filed in court. So all court documents are public documents unless otherwise ordered by a presiding officer or, a judge, whoever has authority in that regard. So that was the consent, to address that consent. So this was an advanced disclosure, but subject that you don't disclose this in advance because others would be in trouble. And that's really, I think, where the issue is going to turn as to this question is, was that appropriate?
Yes. So the spokesperson of the Jacob Zuma Foundation, then Tyrone, arguing that in itself, you release to the journalists and you give them instruction that, no, don't publish it this way, publish it that way. That in itself saying it's irregular.
It may very well be. I really cannot say at this point. I mean, I have not seen precedent, so law dealing with this particular issue. Because the important thing is, I mean, generally in law, we deal with intent. So the question is, do you interpret this action as an action which ensures that you are actually not in breach of the law, but at the same time, you are accommodating convenience? And then if that is the case, can we then impute unlawful action on your behalf? So that question has to be answered. Or do we take a strict interpretation that says, well, let's look at the act. There's been disclosure. It is in advance of the documents actually being filed in court, and so there is a breach. So I'm not sure which way the court is going to lean in that regard. But the important thing for me at this point is, and the question for me certainly is, well, why is this being made about this hurrah about Advocate Billy Downer? Only his name comes up, but he's not involved. He's got absolutely no direct, he's not implicated directly in this action. That's what I find strange is, why not blame the person, at least impute the conduct to the person who actually conducted, who actually did the act, which is Rothenbach. And again, I stand corrected, but I seem to recall that counsel is Rothenbach. And that was admitted, that appeared in court the last time we appeared. So I find that strange. And that to me suggests that, there really is an axe to grind with Advocate Billy Downer.
Prof. Seepe, but of course the disclosure in itself, according to former President Jacob Zuma, then adds to this continued narrative that he has, of course, been putting out there that the law seemingly is treating him differently to what other people have rights to. Prof?
Yeah, if in the course of their duty, the NPA has information, that information is not to be disclosed to people who are not attached to the NPA or the case. So the issue here, as Tyrone also says, is that the court will determine whether there was an intention to manipulate the prosecution or to influence it in a particular way. But what we have a case here that also has a history. Remember, this is not the first time that the issue of disclosure to the media has occurred. There will be also submission, and they also come in affidavit that in the past, Bill Downer was also accused of having given information to Samsol of the Mail and Guardian. So one can begin to suggest that there might be a pattern that is emerging. But what is most important here is that the NPA has no business doing what it does, especially on a matter as sensitive to this, because what we want to do is to make sure that there is no unfair prosecution, there's no manipulation, there's no trial by media. And people are tired of people being tried by media. We remember the case of Duduzane, where he was almost declared a fugitive from justice. And when he arrived, he was pounced upon by the NPA, only for the NPA to prove that it didn't have a case, and they had to try another case. So when you deal with these issues, it's very important that the NPA is seen to be above board. It cannot go to court with dirty hands. So that is an issue that is at stake. So the second other issue is that there are other issues that the President Zuma is raising that have to do also with the behavior of the NPA, not only about Downer. The issue of the Kambebe report, the Joint Standing Committee on Intelligence, suggesting that there might have also have been foreign intelligence groupings that were also participating in this. So the issue here is does Jacob Zuma have a case in terms of the NPA behaving without bias? And that it becomes very important when we deal with issues of law. And the perceptions are important in terms of people saying justice is seen to be done. And I don't think in this case, whichever way we talk about it, it does not give a good impression of the NPA that you disclose information to the public, and what prevented them from waiting. The issue of their convenience is one thing, but the rights of a person who is accused cannot be undermined and compromised on the basis that it will be convenient for us to give you guys this information. So those are the issues that the court will have to weigh.
When we come back, we weigh in on whether or not this has any implications on the permanent of stay application to his prosecution as well, and whether these two are linked in any way. Legal expert Tyrone Maseko and political analyst Professor Sipho Seepe staying with us tonight on In Focus. We're back in a moment. Tonight here on In Focus, Newzroom Afrika, channel 405. Of course, that legal matter that we are dealing with, former President Jacob Zuma laying a charge against Billy Downer for what he says is breach of Section 46 of the NPA Act, disclosing information without permission of the National Director. So, Tyrone, a statement from the NPA saying, no, they're committed to upholding due process. Not only that, they are saying they will assess the merits of this charge in an objective manner. But they also say, we note that these charges are laid while the matter is subject to judicial determination by the High Court in Pietermaritzburg, and judgment is expected to be delivered on the 26th of October. What does this mean that now these processes are now running parallel? While we are waiting for this court decision, a charge now has been laid with the police.
Tam, I don't think there's anything that's running parallel, to be totally honest with you. The case that is before the Pietermaritzburg High Court relates really to the plea that Jacob Zuma has made to the court. Now, this small little issue of, in fact, this particular issue was actually late on the day. It was not really the basis of the original plea, the issue of the disclosure of private medical information that only really surfaced later. That determination is not going to turn on this issue. It's going to turn on the substantive issues that they raised earlier on, and those substantive issues really relate to the issues that were raised at the SCA and in the application for permanent stay of application, which the NPA argues have already been decided on. So, and in fact, I think the learned judge actually did, sort of suggest that really this application is not really going to turn on this issue or this question that they were raising belatedly of the disclosure of the medical records. And so that is a separate issue. And that is why they've now turned to lodging this complaint, this criminal complaint, because it really is a separate issue. But as far as I'm concerned, there's no relation between the two, other than to just be a small little support for that application to show that, well, this is actually continuing conduct that we're complaining about. So I don't think there's a connection between the two. I don't expect the judgment on Tuesday to turn on this issue at all.
So if the judgment is not turning on this issue, then essentially that would mean that the NPA would then need to look into these and conduct an investigation separately without
Correct.
relying on what is going to come out of the judicial process. And what should then follow? I mean, should indeed the irregularities be found and the breach be found, what should then follow? Because former President Jacob Zuma says then that means something must be done to Billy Downer.
Well, therein lies the problem, Tom. Therein lies the problem, because I suspect that what Advocate Mpofu and co are going to seek to do, irrespective of really how far the NPA gets with this decision on whether it's on investigations of this issue and whether to prefer charges against Billy Downer, I think the mere fact that they have now laid this complaint, they're going to make an issue of that to say, well, there is actually a pending case now. They're going to say, well, there's a pending investigation, a criminal investigation against Billy Downer for his actions relating to this investigation or relating to this trial which we're involved in. And so that alone should make him unfit. That's what they're going to try and argue, I suspect. The merits of it, I don't know. I mean, I haven't really thought that far, to be totally honest with you, as to whether the mere fact that there actually is a complaint that's been laid, no decision made in relation to that complaint, does that then, on that basis alone, disqualify him from prosecuting the current trial against Jacob Zuma? But I'm pretty sure that that is the strategy, because conversely, the NPA is in a very difficult position here. They've got one of their own, a very senior prosecutor, a criminal complaint laid against him. A decision needs to be made, and that decision is going to be made by, I don't care who makes it at the NPA, but that person is going to be a colleague of Billy Downer. They're going to raise that issue again of, well, is there bias in that? Are they independent? They make a decision about their colleague. And so it's becoming quite messy, to be totally honest. Who is then fit to make this decision? He works for the NPA. The NPA is going to make the decision ultimately. Can the NPA make a decision? There's no law that suggests that someone outside of the NPA can make a prosecutorial decision relating to a prosecutor. Yeah. So, and trust me, there's going to be a song and dance from the defense about this issue. So, yeah, we're getting into very...
So, Tyrone, and I'm going to bring in Prof in a moment. Say then eventually the eventuality of it, I'm not saying that's what will happen, we don't know what the merits are. The eventuality of it is that Billy Downer is unfit. Does that mean then the NPA case crumbles? The NPA has been telling us they're ready to go on trial. No. Can somebody pick up the trial and still continue without Billy Downer? No. And would that be detrimental to the case?
Well, no. And again, we're into messy territory. Remember, Thabo, that as things stand, Advocate Dalimboff has already argued. That is already, before we even get, I mean, you raise a very valid point, but already, they have already argued that point to say, there's no one who's fit in the NPA to prosecute this case. In fact, if the learned judge were to find in their favor, then it means that they cannot proceed with the prosecution. So that is already a case that is before the court. So Tuesday's judgment has to deal with that issue. Even before what you now refer to, the secondary issue of these charges now having been laid, what then of the prosecution? Does it mean that Billy Downer cannot prosecute? Can someone else then prosecute? Already, that is already before the court. So in a way, we've got a situation where we've got an argument before court with an outcome that they seek, and we may very well, after a decision has been made, so if the court were to find that, no, actually there's no merit to Dalimboffo's argument, they could actually then go ahead and run the same argument in respect of these criminal charges that they've brought against Billy Down and say, well, he's not fit to prosecute and he must be removed. And again, I mean, he's not the only one. And remember, in the statement, it says that and everyone else associated with that disclosure, Rottenbach also, being party there too. So they would eventually be trying to remove the entire team.
Yeah.
Now, in theory, it would mean that if the NPA decided, look, we're not interested in any of this, they could conceivably decide, let's remove the entire all those prosecutors and get a new prosecutor team. But that's only going to really play into the hands of the defense and cause more delays, because to study this entire case and be able to prosecute it, bringing new prosecutors is going to take a whole lot of time. Yeah. And I suspect that might be the design.
Prof, I mean, all these tactics, because, I mean, really, if you look at it, one would maybe want to read it as legal tactics. They add to the perception of the former president not even delaying, actually not wanting this trial to go on, or do they not?
Well, I mean, that's also deal with the most obvious. The manner in which the NPA has been handling this case has been clumsy. You don't need to act the way you've done to give the defense an ammunition to go that route. And they've actually done that. And it's not the first time that these allegations have been raised. So there is a problem. And we also should be concerned, because that's not what we would want. When we talk about somebody having a right to a fair trial, we mean that this clumsiness should not be part of that. So that is the first thing. The second issue is the song and dance that is being raised by the defense is largely around Billy Downer, who seems to have it has become almost personal. And that is the argument that they actually advanced. So the NPA must actually choose that do we actually sacrifice Billy Downer? Are we going to say this case cannot be run? I mean, they need to get to a stage where they say, we want to proceed with the case, and the fact that the work has been done, and we have people who are competent. But you cannot become so obsessed with the fact that only Billy Downer must do it, and then you undermine the whole entire NPA. But as Tyrone says, that it is also possible that once they do that with the Billy Downer, an extension could be made. But the way it is phrased is that all those who are associated with this, and I want to believe that not all members of the NPA could be said the entirety of it was actually involved. So they need to also make it easier. They must accept that it is clumsy and say, well, we have to take ownership of this clumsiness. But also, most importantly, is that justice must be seen to be done. We do not want cases to be run on the fact that I, as a prosecutor, have a personal vendetta against a certain person, that I've invested so much that this cannot continue without me. Justice must go beyond an individual. So this is where the NPA has to also make that decision. But as Tyrone says,
all right, some difficulties there with the connection. To Professor Sipho Seepe, political analyst, they're giving us some closing views around this particular matter and whether or not it adds to the delays that already have been when it comes to this particular matter. I mean, it's over a decade, Tyrone, that this matter has been going on, and it looks like it's still not yet about to go on trial with all these other issues that would need to be dealt with.
True, and because I'm just listening to Prof talking now, and I was thinking to myself, well, what then happens if they were to decide to say, look, for the sake of expediency, let's remove Advocate Downer from the prosecution with all its consequences? Well, what effect does that have? And in fact, does it not embolden the defense to keep playing at the strategy? What guarantee do we have that they will not do this with the next prosecutor? Because, I mean, let's be honest, these delays and all these tactics really only favor one party. I mean, I think it's quite clear, and I absolutely accepted that the state is ready to proceed with the matter now. And I think everyone in the right state of mind can accept that these delays are really being caused by, what if you call them delays, by the defense, who are not allowing the prosecution to proceed beyond the plea at this point. And the question is, who does it favor? And they can only really favor Jacob Zuma. And different people might have different ideas about it. Some might say, well, that is because I don't really have a good answer to the charges themselves. And so if I can hold the process up, then, all the better for me. So I'm not sure that it's going to solve anything necessarily to remove Billy Downer from the prosecution. I accept Prof. Seepe's argument to say, look, we don't need this nonsense. It's taking too much of our time. Why are we defending this prosecutor being on the case if the defense is making a song and dance about it? We want to move on. But what guarantee do you have that if you remove this prosecutor, that you actually will be able to proceed?
Legal expert Tyrone Maseko and political analyst Professor Sipho Seepe. I thank you tonight for helping us in this conversation. Thanks for coming on In Focus.